Good morning again, everyone. This urgent application ex parte hearing is in the matter of CFI 051-2023 and is being held by way of video conference before Justice Wayne Martin, appearing from Australia. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's directions. The claimants are represented by Afridi and Angel. Lead counsel is Mr. Lee Sharma. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Yes, thank you. I so confirm.
Yes, thank you.
Yes,
thank you.
Thank you. Well, thank you, Saeed. Counsel.
May it please the court, may I first of all just check, this is my first appearance in the DIFC courts, that the correct form of address is Your Honour?
Congratulations. Yes, I hope you find it a pleasant experience. Yes, Your Honour is fine. Your Honour is fine. Some judges go by Your Excellency, some local judges, but Your Honour is what I'm used to. So if you'd stay with that, that's convenient.
Thank you. Well, I hope I do find it a pleasant experience. All I can say, Your Honour, is that's obviously in your hands.
Yes. Yeah. All right.
I say I can't actually see you, but it doesn't matter, I suppose, as long as you can hear me. May I just check first of all, Your Honour, which documents, if any, you've had an opportunity to read? I'm conscious this is a.
I've certainly read the application. I've read the draft order. I've read the affidavit. I've cherry-picked through the exhibits to the affidavit. I can't profess to have read all of those. And I've also read the skeleton.
That's extremely helpful, Your Honour. Thank you. Well, I don't know where you would like me to start. I had thought I might just draw your attention, first of all, just to the aspects of the evidence that are disputed, so you can see what really is an issue between the parties.
Yes, that would be helpful. Thank you.
Thank you. Well, in that case, Your Honour, I suspect within the bundle, the first thing we should look at are the affidavits from the defendant. The first is at page 337.
Now, I've been having terrible trouble getting my affidavit to load up because it's in a big bundle on my internet and its speed is quite slow. So I'll press it in, see how we go. But if you keep talking while I try and find it.
If I just tell you, so this is the first affidavit of Mr. CUENDA, or Mr. Lopez CUENDA.
Yes.
And the first affidavit simply is in response to the order from the Hong Kong court asking him to provide information. And the only thing I was going to draw your attention to in that is that in that document, and this is at paragraph 7, which should be page 339 when you are able to open it, page 339, but in any event, paragraph 7 of the first affidavit. And he says, I confirm as of the date of this affidavit, funds had been transferred from the CARMON Hong Kong account to the following bank accounts. And there is then a table, and entry 3 and entry 4 in that table, and it's only 4 entries long, refer to bank accounts, the 2 bank accounts that we're seeking the audit in respect of today. And obviously sums transferred, again, of course, are replicated in the bank account. So in terms of whether you can be satisfied that the defendant has the assets that are referred to, we rely on his own evidence in relation to that.
Well, had the assets. I suppose you don't know whether they're still there, of course, do you?
Well, so you want to be note the position. So as far as I understand it, is that this was information given in response to the order in the Hong Kong court. Yeah. And of course, this was an order handed down either on the same date or a slightly later date, it needn't matter for this purpose, as another order, which of course was the worldwide freezing order. So of course, it's right to say that if he's not complied with that order and has in fact transferred these funds, then he would of course be in contempt of the Hong Kong court.
Yes, well, the trouble is those sorts of considerations don't always prevail. But anyway, we'll no doubt, if you're successful today, you'll no doubt find out in due course whether or not the funds are still there.
Well, that's the thing, Your Honour, and that's why we seek the orders that we do. The first is that we don't know whether they're there or not. We hope they are. But the other thing is that if they are, it is only because we are relying on the goodwill goodwill and integrity of the defendant not to breach that order, because there's nothing in practical terms stopping him. And of course, we would say we're once bitten, twice shy.
Yes, of course. Yes. All right. Thank you.
The second document I'd like to take you to is another affidavit from the defendant. This is his second affidavit, and it's on page 388.
Thank you.
I'll take you to the relevant paragraphs in a moment, Your Honour, but just so you know, you've mentioned already that you've had the benefit of reading the affidavit on behalf of the applicant. And so you'll know that what she says is that he was in charge of the of the Angola company. They were going to set up operations in Hong Kong, and that because she was, or would likely be considered to be, she believed, the owner of this, forgive me, not the person who made the affidavit, but the ultimate owner of the company, was married to somebody of political prominence. There was concern that she either had previously been or would be this time considered a politically exposed person, and so would not be able to open the bank account. And so she said for that reason, although the reason doesn't matter, but what she says is for that reason that this defendant, who was going to be managing the operations in Hong Kong anyway, would set up the company in his personal name and would set up the bank account with him as the signatory. And of course, you'll also know that she says that this was pursuant to a written agreement.
Yes.
I can take you to that agreement if you like.
Yes.
But as I say, suffice to say, there is an agreement there. It's a short agreement, and it appears on its face to have been signed by both parties. And she's given a description in her statement of what that agreement says, but in summary, it's effectively that she is referred to, or rather the Angola company is referred to as the real owner, and he is referred to as the nominee. And of course, you've heard what she says in her statement, Ms. Martins, that there came a point when he ceased cooperating and firstly simply broke off contact, and then it was discovered a short while later that in fact he had changed the login details. Because as I think she described previously, it's not known in fact whether she was the only person in practical terms operating the account, but certainly in the way it was set up, she required the OTP, the one-time passcode from the defendant's mobile. And so, of course, when she was effecting transfers, she required his cooperation. So the implication was that she could go as far as logging in, but as far as the code was concerned, the only person who could give her that was him, because it was simply sent to his mobile, which I'm sure we're all familiar with from our own lives.
Yes.
And so what she says is it became apparent not only shortly after he had ceased contact and wasn't replying to them, that he'd in fact changed this login screen. And so that's why, the basis of the $23 million being sought is that it is said on behalf of the claimant that the last time she was able to see the account balance, there was some $23 million in it. And as you know, the order that's sought is in respect of two accounts. I think it's two different accounts actually, where there's a 17-point-something million and a 3-point-something million, and from memory they add up together to $20.7 million. I think it's not clear at this stage what happened to the remainder of the 23 million. And I think it's also not clear, certainly to me, whether any subsequent funds were transferred in, so that there was a point where that balance later became more than 23 million. We simply don't know that yet, or at least I certainly don't, but for your purposes, it need not matter.
Well, Mr. Sharma, the other question that I had, and we might as well come to it now, was that in terms of the order that you seek, you're seeking freezing of the accounts, whatever the balance, so that if, for example, hypothetically, if there was more in the first account than 3.3 million, or in the second account 20.4 million, that would be frozen as well. So that if money has come from, but I assume you're saying, well, your claim, you have a claim which is substantially greater than the 20.7 million that you know was transferred into those accounts. And so if there is a surplus in there, you'd want it frozen anyway. Is that?
Well, so before this weekend, Your Honour, I would absolutely have said I agree with you. I have to say this weekend, after reading the witness statements in this case, I have probably a different view of what might be considered by some to be a substantial sum of money, because certainly my eyes pricked up when I read that this defendant received, I think you can see at least 3 bonuses in 2019, the lowest of which was $60,000 US, and the highest of which was 11 million. So
yes,
I
that's right.
the first bonus a substantial sum of money, but it might well be pocket change to Mr. Lopez Cuenda.
Well, I've got some people involved in the construction industry in Australia, and after reading the same materials, I was going to suggest they might go and set up business in Angola.
Indeed.
Anyway,
No, certainly, I
but,
would
but
say.
I think that is the answer. Your claim, really, as I understand it, is a claim for assets. In a sense, you're tracing, but in a sense, you're also seeking to put your hands on assets that might be available to satisfy the judgment if and when you get it in Hong Kong.
Yes.
And so that basis of the claim is not limited to the amounts actually transferred in the account, but it would extend to assets generally.
Yes, and I think obviously, we're not involved in litigating the claim in Hong Kong. We're here just to seek privilege orders before you. But as I say, certainly were I involved in litigating in Hong Kong, I would certainly be concerned to find out whether the limit of what needs to be claimed for is just the 23 million, which, as I say, was only the balance known to our client at the last time she was permitted by the defendant to read it.
Yes. Well, if there'll be liberty to apply anyway, obviously as part of any order, and there'll be a relatively short return date. So if there is more money in the account, and the defendant can prove that it came from a source other than a legitimate source other than your client, then the order can be modified. And in the meantime, no harm is done.
Indeed.
Yes. Yes.
You want to
I interrupted you, Mr. Sharma. So go back to
please do. I'd much prefer to answer your questions as they arise and before either one of us forgets them. The document I was going to take you to next, Your Honour, was the second affidavit from the defendant, and that is to be found. Well, it begins on page 388.
Yeah.
It's being shared by my colleague at the moment.
Good, thank you.
And I was going to take you, please, to paragraph 11, which is on page 390.
Yes, thank you.
And you can. I just want to draw to your attention that obviously the defendant has put in an affidavit, and he gives a very different account and explanation for what's gone on. I want to do two things, really. The first is just to show you, in the interest of candour, what that is. But equally, the submission in respect of it is, well, this simply shows that is an extremely serious issue to be tried between the parties. And it's, of course, not for us at this stage to second guess how that might be determined. But there is no doubt that there is indeed an extremely serious issue, because he has an explanation which, if believed, could well amount to a complete defence to this claim.
Yes.
What he says is, and I'll read it slowly, paragraph 11, around 2015 to 2016, CARMON Angola was not doing well and was struggling finding new business. There were even talks of the possibility of closing CARMON Angola. Therefore, I started to look for other investments and business opportunities which I myself can do or invest in. So it's not entirely clear how that is of benefit to the company, but nonetheless, that is the evidence of the witness. Paragraph 14 on page 391. Yeah. Move to that next, please. He says, I started to explore, and I won't take you to every single paragraph, sir, but I can tell you that at paragraph 13, which I wasn't going to take you to, he talks about using his business connections to the Chinese community and developing something through that. So we then get to paragraph 14. I started to explore and negotiate with CR20 and to the possible business deals and ideas. I commenced negotiations on my own behalf and initiative. So he says, look, I wasn't acting on behalf of the Angolan company. I was exploring this for myself. I was never instructed by CARMON Angola to negotiate with CR20. I intended to create a platform to attract business to Angolan companies and to develop my own business.
Yes.
That's his case, and he's entitled to put it. Continues paragraph 15. During the negotiations with CR20, CR20 and I have a reached consensus. So he doesn't say that Angola has. He says at this stage, CR20 and I have. I would use my extensive network of contacts at paragraph A. Paragraph B, I would set up an individual and independent company vehicle as a platform to attract business to Angolan companies. This later became CARMON HK. CARMON HK would continue maintaining business relations and negotiations with CR20. as well as developing its own business and secure financial interests for myself.
Yeah.
If we move now, please, to paragraph 16, which is just on the next page down. Pursuant to the arrangement, and again, this is the arrangement between this defendant personally and CR20, he says, but pursuant to the arrangement, I caused and convinced Carmen Angola, of which, of course, he was the general manager. So it's been a very difficult conversation. I caused and convinced Carmen Angola to agree to the arrangement. I was the only person who had contact with CR20 and negotiated with CR20 to enter the arrangement and brought the business opportunities to Carmen Angola. Therefore, in essence, I was the only person among Carmen Angola and Carmen Hong Kong that actually knew about what happened and was discussed and agreed in the negotiations. He then talks about the memorandum of, I forget what it's, cooperation. And we've got those in the bundle. He says to further secure the arrangement in providing assurance to CR20 that there would be enough resources to execute the building works. Two memorandums, presumably that should be memoranda, were entered between CR20 Angola and Carmen Angola on or around the 11th of February 2016. So, in spite of what he's saying about doing this for his own interests, of course, and again, I'm simply drawing your attention to the fact there is substantive here. The MOCs, the Memoranda of Cooperation, were actually between CR20 and the Angola company.
The company, yes.
Yeah. We then move to the next stage, page down. Obviously, Your Honour, I do invite you, if you wish, to obviously read the statement in its entirety, but I'm just flagging up, I think, the salient point. Paragraph 19, and it's the second sentence in, it was, well, in 2016, pursuant to the arrangement, I set up Carmen HK in Hong Kong, with myself being the sole shareholder and director. Carmen HK's certificate of incorporation was issued on 1st December 2016. It was my intention to use this company as a platform to attract overseas investors and capture business at an international level, and to safeguard my own interest.
But he set it up in the name of the company of which he was the manager.
Indeed. Well, that's dealt with, and that was the next bit I was going to take you to, Your Honour. Paragraph 21. And this is what he says on that in that regard. Obviously, this is the first time we've heard it. By giving Carmen Hong Kong a similar name, not identical name, but simply a similar name, Your Honour. I'm sure the distinction is a very important one. Carmen Angola. It also had the purpose of transferring the goodwill of Carmen Angola to Carmen Hong Kong. That's what he says. That by naming it, it had the purpose of transferring the goodwill in order to build and promote the company image of Carmen Hong Kong, as the objective of Carmen Hong Kong is to make use of business opportunities in the international market to meet the needs of the local Angolan market.
Well, this looks like an affidavit confessing to a serious breach of fiduciary duty to me, but anyway.
Well, Your Honour, that is my client's case. I'm simply drawing your attention to the other side's case. I'm not disagreeing with you. I'm simply discharging the duty of candour.
Yes.
Paragraph 23. I further deny the plaintiff's claim that Carmen Hong Kong was created because Angola faced purported difficulties in opening a bank account in Hong Kong because of political sensitivities. Carmen Angola in 2022 had opened bank accounts in various currencies in Hong Kong, and Carmen Hong Kong had transferred payments to said account by Carmen Hong Kong. And then paragraph 24, the only reason for me establishing Carmen Hong Kong was to honour the agreement reached. And again, this is the arrangement reached. And again, arrangement capital A refers to an alleged arrangement between the defendant and CR20, the Chinese company.
Yes.
The arrangement reached in the negotiation so that Carmen Hong Kong would enter into the consortium agreement with Carmen Angola, and that my interests would be protected by Carmen Hong Kong. And then I'm just going to take you as well to paragraph 26, and it's actually the final sentence, which is on just the next page. Carmen Hong Kong was wholly owned by me, both legally and beneficially.
Okay. Good. Does he explain where the money came from in this affidavit?
Well, I'm not sure that he does. I could be wrong about that. I read it reasonably quickly myself. But it seems what he's saying is this whole notion of me being any kind of nominee, this whole notion of somebody else being the ultimate real owner, as appears to be the nomenclature used in the written agreement, the nominee agreement, he says that's just all wrong. And as I'll show you, he says this is a document on which his signature was forged. Okay. So it may be that the source of the money doesn't matter too much. I don't want to say for certain, but it's not in there. Your Honour. I wasn't specifically looking out for it, and I apologise for that.
That's right.
He then, at paragraph 48 on page 399, paragraph 48, he talks about the lady on whose affidavit the claimant relies. He says, Martins at the material time was my subordinate, and she reported to me regarding financial work. I especially trusted Martins to handle work on a micro level. In fact, before I was forced to depart from CARMON Angola, I considered Martin my right hand concerning financial matters. Although Martins was initially hired for the position of financial coordinator at CARMON Angola, I eventually promoted her to the position of chief financial officer. This reflected the high level of trust that I placed in her back then. As such, I have delegated to her most of the financial duties and tasks. Yes. The next section I'd like to take you to, Your Honour, is on page 400, and it's at the bottom, and the section begins with the title, The Alleged Nominee Services Agreement. It's paragraph 53, and you can see, you can read it for yourself, so the important sentence to note, of course, is the final one. Clearly, therefore, the NSA provided by the plaintiff is forged. That's what he says.
All right.
Yeah. And then paragraphs 55 and 56 are also helpful. The sentence that I've actually highlighted with the intention of showing it to you, Your Honour, was actually the final sentence of paragraph 56. He says, it is absurd that I would sign such an NSA against my own interest, as I also had control of CARMON Angola. I think you may perhaps have forgotten there, sir, about the duties that a general manager owes to a company.
Yes,
but that's perhaps not a matter for this court to consider. No. The next subsection of the statement is entitled Real Estate Business, and it begins here. And just to put this into context, Your Honour, you may recall from Miss Martin's statement that the beginning of the end, so to speak, was when it had been discovered that properties that the claimant contends were owned by, were secretly owned by him. In other words, that they were not aware were rented out. He, in this section, gives, again, it's fair to say, a different explanation. He says that the claimant was fully aware of this, and they needed somewhere for staff to live, and so I think he says his wife did the deal, but I can just show you. It's paragraph 59. However, I've always disclosed my interest in REB with the plaintiff, and it was never a secret. If we move on to paragraph 60, the next page, final sentence, my wife, Michaela Zeferina Lopez Camota Cuenda, leased the properties to CARMON Angola to help CARMON Angola by providing lower rental price and to lessen the pressure CARMON Angola might receive from unknown landlord, as REB was less stringent in requesting payment from CARMON Angola given my relationship with CARMON Angola. And then it's right to say that paragraph 61 in the centre, he says, Martins herself had also rented and lived in one of my houses. And then the final point he wishes to make, and again, one wonders what, if anything, turns on it, but it's paragraph 62. He says, in addition, the leases exhibited by Martins in her affirmation, I think he means affidavit, were signed by one Mr. Sergio Sutinho Floridio on behalf of CARMON Angola. I did not sign the leases as falsely alleged. But of course, he's already told us, hasn't he, Your Honour, that he's in full control of CARMON Angola. So this man was, we would say, directed to sign. The next section in his affidavit, his second affidavit, is entitled Departure from Angola, CARMON Angola. And what he says in summary, first of all, is that the breakup, if you will, was not as amicable as it has been portrayed in the claimant's witness statement. And the height of that is the final sentence that we can see on the page in 63, paragraph 63. And he says, Mayra is defined above. She is the owner of the claimant company. Mayra threw ugly accusations and threats at me and asked me to agree to very unfavourable terms before my employment at Carmen Angola formally ended. My departure from Carmen Angola was therefore far from the relatively amicable picture that the plaintiff tried to paint in its statement of claim and Martin's affirmations. Again, it's not clear whether this is really something in which a case would turn, but it's right to point out that he takes factual issue with this characterisation. And then paragraph 64. Quite important, actually, Your Honour. He says, subsequently, the plaintiff also offered to buy my shares of Carmen Hong Kong, but it was not accepted. Having said so, if Carmen Hong Kong and its assets had ever belonged to Carmen Angola, which is denied, clearly there would be no need for Carmen Angola to offer to buy the shares of Carmen Hong Kong. This thus unequivocal, I presume it means gesture or act or something, there's a word missing, demonstrated that Carmen Hong Kong has to date never belonged to Carmen Angola, whether legally or beneficially. And so it's right to observe in the defendant's absence that this is an explanation which, if believed, could amount to a complete defence. Yes. That's his case, he's entitled to put it, but obviously this is not a case to which the claimant agrees. And of course one might ask, well, if there really were these offers to buy shares, people normally tend to put something in writing, even at the negotiation stage, emailing, how about this, what about this, etc., etc. And of course, that evidence, even if it was just emails passing in negotiation, of course, are striking by their absence. One would expect him to say, as he has in respect to other things, well, I exhibit the contemporaneous emails at the time, in the way that he has, for example, of WhatsApps, which are exhibited to this defendant's statement. But nonetheless, that's his position, he's entitled to put it.
Do we know where Mr. Cuenda is at the moment?
We believe Angola. That's right. What I'm instructed is our belief, but I don't think I can say more than that.
All right. Okay, thank you.
As I look to my colleagues who gave me that information, I'm looking as well at something I was going to draw your attention to anyway, paragraph 66. You can see that the next heading is alleged breach of trust, breach of duty. And he says 65, I was wholly independent of Carmen Angola. Carmen Angola would not be entitled to any beneficial interest from the shares of Carmen Hong Kong nor its assets. Neither Carmen Hong Kong or I are holding any properties or funds or shares on trust for Carmen Angola. Of course, that's the issue for trial, isn't it, Your Honour? Yes. Whether money that is there, is accepted to be there, who it belongs to. And then he says C, which amounts to the same thing. Carmen Hong Kong and its sole owner, i.e. me, are entitled to freely utilise the funds held by Carmen Hong Kong that were received and kept pursuant to the consortium agreement. Yeah. He then says paragraph 66, and this is why I think my colleagues might be right about where he is currently located. He says, further, I have been advised by my Angolan lawyers that Angolan law does not recognise the concept of a trust and a split between legal ownership and beneficial ownership. And he then goes on to say at point B, the consortium agreement as interpreted under Angolan law. And he then says at C, there's no breach of any director's duty by me. The next section, which I needn't take you to in detail, it's just on page 404, after the paragraph I just referred to, no breach of director's duty. That's entitled Luanda Court in Angola as the proper forum. So he's obviously got some reasons, whether he's located there now or normally or not, but he wants the Luanda Court to be the proper forum. Again, he's entitled, I think he's either has or is about to make those representations to the Hong Kong court. And again, that's something the Hong Kong court will decide.
That's the basis of the jurisdiction application in Hong Kong, is it?
Well, I can't say I've cross-referred the two on the same page together, but it's certainly been the way that he wants to summarise his position.
Yeah, makes sense, yes, right. Yes.
And then there's just a final paragraph about discharge of injunction in the Hong Kong court. And you can see on the final page that this was his position as of the 8th of June 2023.
Thank you.
That's the date of this affidavit.
Did he give his current address in either affidavit, Mr. Sharma? Are you able to help me with that?
Yes, he does. It's in Angola. I'm just scrolling to find it for you. Or at least my colleague is. I'm very grateful to him.
Oh, there it is. Yes, I've got it. La de Patriota, Rua 51 491, Talatona.
Yeah, that's good.
I'm just thinking of service, and I just wonder if he should be served there as well. What do you think?
Yes. So we obviously want this to be brought to the defendant's attention because we want him to comply with it. And if it's not brought to his attention, then of course he would not be in contempt if he disobeyed it. So we are very happy to serve him in as many different ways as we can think of.
All right. Well, I think it would be helpful when we come to that. I think he should be served both by dispatch to his lawyers in Hong Kong and also to that address in Angola.
Thank you, Your Honour. Delighted to do that. Your Honour, forgive me, I can't see you, and that's our fault, not yours. So just tell me when you're ready and whether there's anything else you'd like.
I'm ready for you to proceed, Mr. Sharma.
Yes. So
you should actually regard it as a blessing that you can't see me, I think, Mr. Sharma. Anyway.
I don't know what you would like me to address you on next. Are there any other factual?
No, there aren't. Thank you. That's been very helpful because I was going to ask you about the lines of defence, and you've covered that question, so that's very helpful indeed. I'm in your hands. I mean, as you've seen and you've identified, I'm aware of the authorities in this area relating to jurisdiction, and I'm responsible for one of them. And so
yes,
I don't have any concerns about jurisdiction.
And in terms of whether the relevant tests have been met, is there anything that you need on in that regard?
No, I mean, as I say, I see it, and as I said in Latif and Laila, I see applications of this kind as really consistently with what the Privy Council said as part of the enforcement jurisdiction of the court. Yeah. So the critical question, as I see it, and you referred to Cyanamid in all of those cases, the critical question, I think, is whether there is an arguable case to the effect that there is a significant prospect that there might be a judgment obtained in the foreign proceedings which could be enforced in this court. And the answer to that, I think, is yes. The Hong Kong court is obviously satisfied that there was a sufficiently arguable case in order to justify the grant of the both domestic and worldwide freezing orders. The order that you seek is entirely consistent with the orders that have been made by the court in Hong Kong. Of course, if the Hong Kong court were to uphold the objection to jurisdiction, then different considerations would apply, possibly because there wouldn't be any foreign proceeding in aid of which this order could be made. But that's not an issue we need to confront at the moment. So as I say, I think there does seem to me to be a sufficiently arguable case. The order you seek is consistent with all of that. I can't see any reason why I shouldn't make the order.
Yes, and so the only thing I would add, of course, is that one has to distinguish, doesn't one, between an arguable case in terms of the facts or the law. And it seems to me that legally, there's no question that if the factual position of the claim is accepted, then the judgment naturally follow. And as to whether the factual position is resolved in favour of one party or the other, well, of course, that is the function of the trial court to determine. And of course, that's why, of course, in American Cyanamid, they talk about is there a serious issue to be tried. There's no legal hole in the case, if I can put it that way. It's just a matter of fact to be decided by the judge.
Yes, that's how I see it too, Mr. Sharma.
Thank you.
Well, do you want to work through I'm in your hands, but one thing we could do is just work through the draft order. Would that be a convenient course now, or are other things you'd like to address?
No, that would be the right thing to do.
Well, let me just pull it up. In terms of the date for the return, I was going to suggest Friday, the 4th of August. Is that convenient to you?
4th of August?
Will that give you sufficient time for service?
I'm just looking at my
Friday
colleagues to confirm that. 4th of August is
Friday week.
Friday week.
1 week. 2 weeks.
Yes.
Hang on, I just looking. You've asked for 14. No, that's not going to work because you've suggested 14 days for the provision of an affidavit relating to the balance of the account. So we should probably wait for that to happen, shouldn't we, before we come back, or not?
I'm just thinking, obviously, there might be different concerns on the respective sides of the case.
I agree. I think we should probably put it on sooner rather than later. If after being served, Mr. CUENDA wants an adjournment, he can ask for it, and no doubt it would be granted. But I think we should give him the opportunity for a prompt hearing if he wants it.
Well, yes, because he might want to come quickly and say, please discharge this freezing order for the following reasons.
Is Friday week convenient to you, Mr. Sharma?
I believe so. I just do as I'm told.
All right. Well, shall we fix it then for 10 a.m. Dubai time on Friday, the 4th of August?
Thank you.
Now, that's item 1.3. I think everything, I've looked through this before. Service. We need to amend that. If you, I wonder, Mr. Sharma, if you could provide a revised draft order,
Of course.
to the court. If you could amend 5.1 to include the address in Angola.
Certainly.
And then yeah, I think the paragraph 9.1, I think those hours are out of date because the court now operates Monday to Friday.
Certainly, we will certainly check and amend that.
Yes. And then in relation to costs, I'm disinclined to order costs against somebody who isn't here. Perhaps we make costs, either reserve costs or make them in the cause.
Certainly.
Right, reserve or in the cause.
Do you have a preference as to what would?
I don't mind. So we perhaps make them in the cause of the application.
Well, that's what I was going to suggest. Cause of the application. Yeah.
All right. Well, that's all I had. Is there anything else you wish to raise, Mr. Sharma?
No, thank you, Your Honour, but thank you for asking.
Well, if you could ask your instructors to fire that off to the court as quickly as possible for attention of Saeed, he will then put it into form for the court. He'll send it to me for approval, and we can issue as soon as possible.
Certainly. I'm just being asked one of my colleagues to draw your attention to 6.1, and just to make sure the court's happy with that.
Yes, I am. I mean, the bank is really, the bank's the most important person to serve, obviously, for obvious reasons. So no doubt you'll serve them ASAP. And then Mr. CUENDA can deal with it from there. But of course, if, as you say, if he was going to do anything about this money, he would have done it by now. So you would think. So
yes, obviously we have the counter argument, which is that we'd all look and feel pretty stupid if he did it now.
Yes, that's right. Yes. All right. Well, unless there's anything else, those will be the orders, and the matter will be adjourned until 10 a.m. Dubai time on Friday, the 4th of August, or such other date as the parties might agree.
Thank you very much.
All right. Well, thank you very much for your assistance, Mr. Sharma. All right.
Thank you.
Court will now adjourn. Thank you.